Professor William Lay. I first met William more than 40 years ago. And William is the director of the School of Public and International Affairs at the University of Bridgeport, chair of Criminal Justice and Human Security at the University of Bridgeport, or Bridgeport University. He got his degree from Columbia Law School. He was editor of the Columbia Law Review. He worked for one of the top law firms in the United States. He was a senior clerk to Justice of the New York Appeals Court. He's written many articles, and he co-authored a book with Dr. Ward on comfort women memorials in the United States. I've read it. It's an excellent book. I highly recommend it. So without further ado, I'll turn it over to Dr. Lay.
I'm very happy to be part of our program here and on the topic of rule of law and human security. And what I particularly want to talk about is the struggle of courts to identify rights that are deserving of special protections, which they sometimes call fundamental rights. And particularly, I'm going to be focusing on the United States Supreme Court and United States constitutional law. The human security concept probably has its origins in Franklin Roosevelt's For Freedom speech given at the conclusion of World War II, at which time he was pondering what kind of a world would be necessary to avoid another conflict such as World War II. And he said that it would be a world where there was freedom of religion, freedom of speech, freedom from want, and freedom from fear. And human security theorists do often focus on, let's say, just freedom from fear, or freedom from fear and freedom from want. But I think the entire context of four freedoms is very important. So what role does rule of law, or what role in general does government have in securing those freedoms? We had some interesting ideas come out in the last panel, by the way. But let me get to that momentarily. Dr. Sala quoted from the preamble of the United Nations Charter, "We the people of the United Nations." I actually want to quote from the preamble of the United States Constitution, in which there is this language which I always find intriguing. The preamble perhaps sets forth the purpose of the United States federal government, and it has a number of provisions: provide the common defense, secure domestic tranquility. The one I find most intriguing is secure the blessings of liberty for ourselves and our posterity, which I think is religious terminology. There is no mention of God in the U.S. Constitution, although it does state that it was signed in the year of our Lord, 1787. But realistically, that wasn't homage to Jesus Christ. That was just the way they denominated the years. But there is this kind of religious language at the very beginning, a concept of securing the blessings of liberty. Actually, the ancient Code of Hammurabi was said to describe how the people needed to behave in order that they would be blessed by heaven. And the idea that, the idea that there had to be some kind of national conduct in order to secure the blessings of liberty is an interesting one. Okay, so what role does government play? The states at the time of the American founding possessed vast powers known as the police power. And the federal government also has a certain police power, although perhaps not as great as the police power of the states. Here's a quotation from a late 19th century case in which the state of Illinois had curtailed property rights. And property rights were extremely important in the early part of American history. They had a very expansive view of property. And in Munvey, Illinois, the state of Illinois was cutting back on property rights. And Justice Waite wrote that the police power is the power to govern men and things when such regulation becomes necessary for the public good. These are very sweeping and broad terminology. Here's Justice Wade again in a case, a somewhat later case, in which he says, you know, it's hard to define the police power, but no one denies that it extends to all matters affecting the public health or the public morals. So the government has a power to regulate public morals through the police power. Are there limitations? Well, one limitation is expressed in this ancient Latin maxim, lex injusta non est lex, which means an unjust law is not law. Now that was articulated by Aristotle, that was repeated by Aquinas, it was repeated by Martin Luther King in his letter from a Birmingham jail. So arbitrary power enforcing its edicts to the injury of, oh, and this, by the way, is a case. This is a Supreme Court case from the late 19th century, which basically restates the same idea. That if arbitrary power enforcing its edicts to the injury of persons and property of its subjects is not law, because it doesn't conform with the transcendent natural law. This is the Supreme Court in the Hurtado case. So, the judiciary has a power to strike down legislation, the product of the democratic process, when it deems that it is inconsistent with a higher law. This is actually found throughout American constitutional law in one form or another. Hamilton in Federalist 78 had said that the judiciary would be the least dangerous branch of government, and I tend to agree with that because it would only deal with disputes that came in the front door. It would only create law when parties with disputes needed resolution of those disputes. And I know Professor Dunn is going to talk about that whole adversarial conflict resolution aspect of the judiciary. Nevertheless, I don't know why my slides are going on their own. Sorry. Maybe I'll stand back. But courts do have a power to thwart the democratic power of the legislature when they uphold what they deem to be transcendent rights. Let's say constitutional rights or rights finding their source in something else. Now, in this Munn case, the United States Supreme Court said it was not the role of the Supreme Court to strike down the rules, the legislation of Illinois, which had infringed public property, and said, rather, for protection against abuses by legislatures, the people must resort to the polls, not to the courts. This is very interesting. Nevertheless, the courts, especially the Supreme Court, has found a way to strike down laws that it considered to be contrary to fundamental rights. Now, a lot of that is based on the due process clauses, which I put up on the screen. There's two due process clauses in the U.S. Constitution. One applies to the federal government, the other applies to the state. No person shall be deprived of life, liberty, or property without due process of law. That's the Fifth Amendment. And the 14th Amendment, no state shall deprive any person of life, liberty, or property without due process of law. Due process is connected with basic fair procedures. I mean, the word process suggests procedure. And fair procedures, again, that's another topic that Professor Dunn may touch on, letting people have notice of what the dispute is, have an opportunity to be heard, in most cases have an opportunity to hire an attorney to represent them, which although attorneys are maligned, frequently maligned, it's very important to be able to have that kind of assistance in a dispute situation. Substantive due process is a doctrine of the U.S. Supreme Court that goes beyond fair procedure. Substantive due process says that the laws themselves must be fair and reasonable and further a legitimate governmental objective. And and actually the Supreme Court sometimes talks about legitimate governmental objectives, and it sometimes talks about compelling governmental objectives. They've devised different levels of tests for striking down legislation. One test is called the reasonableness test. That is, if there's a reasonable basis for the law, it shouldn't be struck down. That's the test, I call it the test you cannot fail, because you can always come up with a reason for the law. The higher test is the strict scrutiny test, which says that it has to be a compelling government objective, and if there's a less restrictive means of attaining it, that law will be struck down. Historically, this doctrine was originally used to, in the economic liberties area. And however, historically now, the court no longer protects economic liberties, and that's sort of the central thrust of my point this afternoon. But I did want to expose you to some of this interesting language. Here's a case upholding rights of property in Calder v. Bull, which had to do with the ex post facto clause. And the court said the general principles of law and reason forbid the act of the legislature that was being overruled there. In a slightly later case, Fletcher v. Peck, where an act of the Georgia legislature was struck down, the concurring justice said, and I love this language, that what the Georgia legislature was trying to do, which was rescind a fraudulent land grant where the legislators had been bribed to sell land for a penny an acre. The Supreme Court said you can't do it because of the sacredness of property. And the concurring justice said, we make this decision on the reason and nature of things, a principle which will impose laws even on the deity. And I was chatting with one of our theologians on the bus yesterday, and I said, this conundrum that Christianity's been debating for centuries, which is whether God created the natural law or whether the natural law is imposed on God, Justice Johnson had an opinion on that. That the natural law is so basic and fundamental that even God can't change it. Well, I'm sorry, where am I? I don't know why my slides are on there, going on their own, but the striking down of laws that infringed economic activity is thought to have reached its pinnacle in the case of New York v. Lochner. And I won't go into the details of the Lochner case because of time. But what in a way is more interesting to what I'm trying to say is the dissent. In the Lochner case, the Supreme Court found a constitutional principle that prohibited the state of New York from regulating the hours of a baker. And it said that basically the opinion was that it is an inherent right to be able to sell your labor and to contract freely without state interference. So it struck down the type of regulation that we would consider very commonplace today. And in his dissent, which came to be the prevailing view, Justice Holmes said that the Constitution was not intended to embody a particular economic theory, whether of paternalism or of laissez-faire. So, and this is really the crux of what I want to say today. The old public religion that guided American constitutional law was connected with upholding what I would call laissez-faire economics. And it in a way was dedicated to this sort of libertarian view that only a minimal state limited to enforcing contracts and protecting people from force, theft, and fraud is justified. But that has been replaced, I would argue, by a new public religion based on laissez-faire morality. Or in other words, government no longer has that police power, that power to support morals. You know, it's interesting. We heard from President Goodluck Jonathan, president of Nigeria, an extremely important country in Africa, and he, in opening plenary session, and his human security analysis was that Nigeria needs good people coming from good families who actually practice the virtue of love. how can this be done? How can this be brought about? What role does the government play? What is the significance of the government's police power to, let's say, regulate morals or encourage moral behavior? I argue that the new public religion in the United States is a religion of laissez-faire morals. Only a secular state that does not intrude in personal moral choices is justified. And so we have a series of cases striking down government interference with personal moral choices. And I want to make clear, I'm not an advocate of the intrusive state that will regulate all aspects of human life, but I am calling for a consideration of the role of the state in assuring moral conduct. In the Griswold case, a very curious case involving contraceptive laws in the state of Connecticut, Connecticut was restricting the availability of contraception, okay? And one of the justices called it an uncommonly silly law. But in striking it down, Justice Douglas said that they were dealing with a right of privacy older than the Bill of Rights. So once again, he's invoking some kind of natural law understanding that prior to the Constitution and prior to the Bill of Rights, there was a natural law restricting government involvement in human life. And Justice Black, dissenting, said, I like my privacy as well as the next one, but I am nevertheless compelled to admit that government has a right to invade it unless prohibited by some specific constitutional provision. But what we've actually seen is the rise of non-economic substantive due process, the enforcement of the laissez-faire morality, the religion of laissez-faire morality, where the government is not allowed to legislate involving moral choices, sexual choices, defining marriage, and things like that. And I think there's a certain, we talked about listening to the people. Dr. Salah talked about listening to the people. The people have been disenfranchised by this process. For example, in the Roe case, which found the abortion right in 1973, a lot of states were moving in the direction of allowing abortion. There was a process going on, but the Supreme Court, in a way, attempted to solve the problem once and for all through the Roe decision. And as a result, arguably, we have had, in America, 47 years of continued unrest, demonstrations, continuous hostility, even homicide against abortion providers. Perhaps it could have gone a different way if the Supreme Court had not taken that position and tried to solve the whole problem in a way not unlike the way they tried to solve the problem of slavery in the Dred Scott case. Well, let me go ahead and finish by saying one more comment. At the opening plenary session, Mr. James Rogers he mentioned that in his view, Koreans fear nuclear weapons from the North. But then yesterday, I think it was yesterday in one of our sessions, Mark Vogelaar said that turns out Koreans are not afraid of attack from the North. I've talked to Koreans, and I have close Korean friends, many of them, and I would say that more than attack from the North, many Koreans, especially older Koreans, lament the loss of so much of their traditional culture. We saw that Shimjung ballet, didn't we? I've lost all sense of time. Depicting filial piety, depicting traditional Korean morality. More than weapons from the North, it may be that many Koreans lament the loss of a certain family-supportive, moral-supportive culture. So those are some thoughts that I wanted to share with you. Thank you.
Thank you very much.